Minya, Mamma was saying, I remember Wakwaba. Deputy Attorney General, Aba Bedin Kobo, mine or you're very serious. Now, here, a Jumano, the Nukra edge of whom essay nunqua. Hey, yes, say, Ubi Fio Quine Ewa, no obedience so a waiting. Lawyer Atta Kyea, actually say, Unimlano, but Deputy Attorney General was say, His Excellency John Dominic Mahama Sebe, one fro bikeke, and no deni betnaho, or don't so actually say, or don't so Unimlano. Oba bedin komo oni Evans ewo PM Espresso minia na nkomo amano watwetwe no ebi akwama lawyer Atta Kyea na Ghana Bar Association obonso de nsembi eba betu dwa na efo Chief Justice eho ene insensem ya ekoso efa legal vacation no eho no minia nsebebri akoso Ghana memo ha migidi se wate ho asem na kasa legal vacation kura eyeden ya minia Deputy Attorney General Justice Remsai Oba bedin komo e dia fa sansem ni nyina ho me ma me kasa enye tenti ma yemko ne yemko tie nsem a justice wa kana komo no emu ede enti mesrew se obehwe video no e dia kwakosi awieye me fa sa konya wi so na masrew unya en subscribe to this particular channel na wa subscribe e dia ma me like video wi na share ma wi bi no nso onya bi ehwe afi yemko na yemko tie nkomo hwehwem beda wase.
I was just making the point there that when you walked in, you were in a suit and a tie. Everybody else should be on vacation. It's a legal vacation. Why are you still working?
Yes, so I think vacations are good. Everybody likes it. I like it too. But this particular vacation, what we call legal vacation, as far as my understanding goes, is for judges, not for lawyers. Sometimes we lawyers, because judges go on vacation, so the lawyers who do a lot of litigation, we tag ourselves along so we can get some little rest while they are on vacation. But speaking about legal vacation is for judges. In some jurisdiction, they call it judges vacation. It's to let the judges, have a rest. And not even all judges. I think that's one thing we need to the public need to be aware of. It's not all judges, the superior court judges who are entitled to these vacation. But so if you go to the lower court, district, magistrate court, circuit court, they don't even have these vacation. They work and they are working as we sit here. So it tells you that it is not a time for the judiciary of any country to stop working at all.
But would you take a break?
I'm entitled to annual leave like any citizen
during this 2 months that they.
No, I can't take any break, any vacation now because of the way our work has been scheduled. I may take my annual leave sometime later in the year, but for now, I'm working.
I don't envy you because your work is just crazy schedule.
Yeah.
There's only one deputy, is there?
Yes.
So you're the only deputy.
Yeah.
And I know when it comes to the Attorney General's office, the deputies tend to do a bulk of the work. It's almost what happens in chambers, right? The juniors do bulk of the work and then the seniors go to, which is what I see is happening with you. It's good because your boss has, trusted you.
Yes. And I need to, say this. My boss has been very, he's been a teacher and it was my teacher as well, so law school, and I've done some work with him before, and I'm very happy that he's giving me this opportunity to put myself to use, and also to the president for giving me this opportunity to serve my country. I was speaking with a friend. Sometimes we, as appointees, sometimes we talk and we share our tiredness and frustration and happiness. And I was talking to a friend who said something which stuck with me since then. He said, look, this is the least we could do for our country, but most importantly, you want your kids to grow, and then when they grow, they will say that their father was here and did this much. And that is very important. You are not sitting down as a lazy person who is just wasting the taxpayers' money. So we try to do our best and sacrifice a lot to do this. But mostly I thank my boss for this opportunity.
Let's talk about the legal vacation now in a serious sense. Today, the legal vacation controversy came back to affect one of the cases that we are prosecuting, possibly almost all the cases are prosecuting, but particularly the Hanan case with the buffer stock. Is now in a Dubois today, just a short while ago, have all been frozen almost, waiting the outcome of the Supreme Court's decision on that. First of all, the decision of the court. I know you stood on your feet in court today and raised objections. You wanted the case to go on.
Yeah.
The judge felt two schools of thought. You would take the first school, which is that once the case has gone to the Supreme Court, wait. You disagree with that school of thought?
Yes, I do. The danger with that school of thought, which allows, which says that proceedings must stop simply because some person or a party or a plaintiff has gone to court to file a suit. The danger with that is that then any person can file a suit, and on the face of, regardless of whatever, in the face of it, say that this court is injuncted. And if all judges go this way, what it means is that then plaintiffs, in this case, the person is not even a party to the trial. He is a random person who says he has an issue, a constitutional issue, and then goes to Supreme Court to file that case, follows it up with an injunction, and on the face of the injunction simply says that Court 1 and 2 of the specialized division should not work. And you are wondering, why is he even saying Court 1 and 2 and not all the courts that are working during the vacation?
And for the purpose of my audience, this is Kojo upon Kruma.
Yes, Kojo upon
versus
Kruma.
Yourself as the Chief Justice in the matter of the debate around the legal vacation.
Exactly. So the concern of the plaintiff, Kojo upon Kruma, is that the CJ's warrant for judges to sit and conduct cases over the vacation is unconstitutional. That's the substance of his case. There are about almost 30 judges or 30 courts sitting. So why single out only 2? And I think that is as a result of bad faith. You see, you don't use the law or the legal process to achieve another purpose than what it's designed for. So the fact that you have chosen even 2 instead of all the courts that are working with the warrant tells me that you have an I won't call it ulterior motive, but you have an auxiliary purpose that you want to achieve, but you are just using the court process to achieve that.
But you see the court's point in this matter. I mean, the Supreme Court is, is the apex court. If they're going to decide on whether or not he can sit, because that's basically is the decision the Supreme Court will have to render. He will just have to wait. I mean, a few more days. It makes sense, does it not? That just simply to wait.
Like I said, the decision of the judge is not out of the law. It is within law, right? But it's also policy based in the sense that tomorrow, that's the danger in these things. That is why if you're in the court, you realize that I cited about 4 or 5 cases where the court said that when public authorities are performing their function, it is not a private issue. So the courts distinguish between 2 private persons fighting in court and one getting an injunction, from where the public authority is working for the general good of the country, and then one person goes to court to say that I disagree with this, and then the person applies for injunction and expect that the whole public, what is being done for the whole public, should stop pending the decision of the court. So the courts have consistently held a view that this is not applicable, this principle is not applicable when it comes to public law matters, because the public law matters affect the whole country. So one person cannot come and say he's filing an injunction and then the whole public have to wait. Even in the recent case of against the District Assembly Common Fund, the same principle was established again. So the courts always draw a line between private matters and then public law matters. And in public law matters, the position has been that an application for an injunction does not stop a public office or public official from functioning pending the determination of the injunction itself. So I'm vacation court judge sitting in court A. Because there are other matters that may be urgent in court B, C, and D, the Chief Justice often attaches other courts to vacation court A. It is only when those other cases come that the vacation judge will not hear the merits and will conduct only the motions and the urgent matters. But when it comes to his own court, he hears not just the motion, but he hears the merits of the case, because he knows that he will also be going on vacation. So if you apply the GBA interpretation, what it means is that then this judge will not be able to hear any case until January next year. Because then when the others come, he goes on vacation and another judge cannot hear his cases. So it's bizarre. And I think for now, there's ample evidence, even from the media. Journalists have been able to pull out several cases, instances where courts have conducted trial, superior courts have conducted trial during the legal vacation. So one of our attorneys just, we're going through our files, they reminded us that even the Takoradi girls case said it was conducted during the legal vacation. I didn't even know. It was conducted during the legal vacation, even amid protest from defense counsel. So it is also not true that before a judge will conduct a case during the vacation, the lawyers must agree. What it means is that now lawyers are deciding how cases should be conducted, which is never the essence of establishing a judiciary. Because for every case, one party wants it fast, while the other wants it slow. Because the interests of lawyers never merge. That is why we need a judge to balance the interests and give us where justice will be.
And you want this fast?
I want it fast. And I want it fast because the constitution demands that we conduct trials fast, quickly, speedily. It's a constitutional provision. Article 19(1) says that every accused person is entitled to fair and speedy trial, and that trial should not be delayed. And I believe that it is also in the interest of the accused person, whatever allegation is put on you, to quickly have it determined whichever way, one way or the other, so you know your fate. But I'm also a legal practitioner and I've done private practice before. And I know while in criminal matters or even in civil matters, one lawyer would say that I want it slow.
Why?
Because evidence is fungible. Evidence is fungible. So as you proceed slowly, witnesses may die, so many things can happen. So the delay may be beneficial to an accused person because the standard of proving that someone is guilty is very high, and you are relying on evidence, documents, electronic evidence, and all that. And all those things are fungible. They may deteriorate with time. Memories may fade. So there is a good reason why, an accused person and his lawyer will want a trial to slow.